NCLT orders liquidation of Rao Edusolutions. Big insolvency lesson every director must know. Welcome back to Corporate and Securities Law Compass. Today we are discussing a real NCLT case that every company secretary, director, insolvency professional, law student, and business owner should understand. Imagine this. A company gets admitted into Corporate Insolvency Resolution Process. The resolution professional works for months. The Committee of Creditors waits. Potential buyers are invited. Extensions are granted. But no valid resolution plan is approved. What happens next? Can the company continue forever? Or does the law require liquidation? In this video, you will learn the complete legal journey of Rao Edusolutions, why NCLT ordered liquidation, which provisions of the Insolvency and Bankruptcy Code apply, what powers the liquidator receives, why the board of directors immediately loses control, what practical lessons every company and insolvency professional must learn. Stay till the end because this case perfectly explains why liquidation is not a punishment but the final legal stage under the Insolvency and Bankruptcy Code. Let us begin. Rao Edusolutions, also known as Rao classes, entered Corporate Insolvency Resolution Process after an operational creditor filed an application under Section 9 of the Insolvency and Bankruptcy Code. The application was admitted by the NCLT. Once the application was admitted, the Corporate Insolvency Resolution Process officially commenced. During the insolvency process, the resolution professional invited expressions of interest from prospective resolution applicants. Several interested parties came forward. Even the promoters showed interest. However, no successful resolution plan was approved by the Committee of Creditors. One proposal submitted by a suspended director was incomplete. The mandatory earnest money deposit was not properly supported. The check issued towards the deposit was dishonored. As a result, the resolution plan could not be considered valid. Eventually, the Committee of Creditors voted with an overwhelming majority in favor of liquidation. Now let us understand the legal provisions. Section 9 of the Insolvency and Bankruptcy Code. This section allows an operational creditor to initiate corporate insolvency resolution process when a default has occurred. After the application is admitted, the moratorium begins and the insolvency resolution process starts. Next comes the most important provision. Section 33 of the Insolvency and Bankruptcy Code. This section provides that if no resolution plan is approved within the prescribed corporate insolvency resolution process period, or if the Committee of Creditors decides to liquidate the corporate debtor, the adjudicating authority shall pass a liquidation order. This is exactly what happened in this case. Since no successful resolution plan emerged within the prescribed period, the Committee of Creditors recommended liquidation. The NCLT had no option except to pass the liquidation order under Section 33. The tribunal appointed Bharti Daga as the liquidator. Now let us understand what changes after liquidation begins. The powers of the board of directors immediately cease. The powers of key managerial personnel also come to an end. The liquidator takes complete control of the company. The liquidator collects all assets, verifies claims, protects the value of the assets, sells the assets according to law, and distributes the proceeds according to the priority provided under the Insolvency and Bankruptcy Code. The NCLT also directed the liquidator to submit the preliminary report within 75 days in accordance with the Insolvency and Bankruptcy Board of India Liquidation Process Regulations 2016. Many people ask, why did the court pass this order? The answer is very simple. The objective of the Insolvency and Bankruptcy Code is resolution first. Liquidation is always the last option. However, the law also ensures that insolvency cannot continue indefinitely. When no viable resolution plan is available and the Committee of Creditors decides that liquidation is the only practical solution, The NCLT is legally required to pass a liquidation order under Section 33. This order protects the interests of creditors, ensures fair distribution of assets, etc., prevents unnecessary delay, and brings legal certainty to all stakeholders. Now, let us discuss the practical lessons. Always submit a complete resolution plan. Ensure every mandatory requirement, including earnest money deposit, is fulfilled. The Committee of Creditors plays the most important commercial role during insolvency. The NCLT normally examines legal compliance while respecting the commercial wisdom of the Committee of Creditors. Directors should understand that once liquidation begins, their management powers immediately end. This case clearly demonstrates how the Insolvency and Bankruptcy Code balances business rescue with timely liquidation. If resolution succeeds, the company survives. If resolution fails, liquidation follows. That is the legal framework created by the Insolvency and Bankruptcy Code. If you found this explanation useful, please like this video, subscribe to Corporate and Securities Law Compass. Share this video with company secretaries, chartered accountants, insolvency professionals, law students, and directors. Thank you for watching. See you in the next corporate law explanation video. Welcome to Corporate and Securities Law Compass. I am a member of the Institute of Company Secretaries of India, ICSI, and currently serve as a company secretary. The views, opinions, interpretations, and explanations shared on this channel are strictly my personal views and are provided solely for educational, academic, and informational purposes. The content published on this channel does not represent the views, opinions, policies, or official position of my employer, any company with which I am associated, any client, or the Institute of Company Secretaries of India, ICSI. All examples, case studies, and discussions presented on this channel are based on publicly available information, applicable laws, statutory provisions, judicial pronouncements, regulatory materials, or are purely hypothetical for educational purposes. I do not disclose, discuss, or use any confidential, unpublished, or proprietary information obtained through my professional employment. I fully comply with the SEBI Prohibition of Insider Trading Regulations 2015, the Companies Act 2013, applicable laws, professional confidentiality obligations, and the internal policies of my employer. Nothing contained in this channel should be interpreted as the communication, disclosure, or use of unpublished price-sensitive information, UPSI, or any information that may violate insider trading laws or other legal obligations. This channel does not provide legal, tax, investment, financial, accounting, or any other professional advice. The content is intended solely for educational and informational purposes. Viewers should consult qualified professionals before making any legal, business, compliance, taxation, accounting, or investment decisions. Although every reasonable effort has been made to ensure the accuracy and reliability of the information presented, laws, rules, regulations, circulars, and judicial interpretations are subject to amendment and change. Accordingly, neither the presenter nor this channel shall be responsible or liable for any loss, damage, liability, or consequences arising from the use of or reliance upon the information provided. By accessing or viewing this channel, you acknowledge that you have read, understood, and agreed to the terms of this disclaimer.